Hi, everyone. Looks like a small group tonight. I'll just give it a second here. Okay, we'll go ahead and get started. It's nice and small. I think it probably will be small. We might get a couple more people. So, hi, I'm Jen, and I'm the Executive Director of Arise Immigration Services. We have a dual mission. We provide free legal representation to asylum seekers in Pittsburgh and training and mentoring to advocates around the country as we work on our cases together. So tonight's chat is part of a larger series through the Collaborative for Immigrant Impact here in Pittsburgh. And the series is designed to equip lawyers who don't practice immigration law to take on pro bono cases. So if you have questions about that, let me know. I can connect you to Jorge, who handles the administrative side of that. Um, I am putting in the chat a link to the slides that I'll be using because some of the slides are kind of designed to be like a checklist, so they should be helpful in practice. If you want a certificate of attendance, just shoot me an email. I'll get that to you. And I will go ahead and share my screen. And this will be just like one of our normal presentations. Feel free to stop me if you have comments or questions. The goal is to Oops, I lost it. The goal is to give you a sense of what you actually file for an affirmative asylum case. Oops, there we go. Okay. So what you include with your application for asylum. Okay, because it's a lot of stuff. I may have mentioned this in a previous training. AILA did a study on this. That's the American Immigration Lawyers Association. This was over 10 years ago. And at that time, the average asylum case took over 100 hours to compile. Asylum law has become way more complex in recent years, so it takes on average more time than that. So it's a short-ish application. It's detailed, of course, but everything that you're filing in support of the claim is a lot. So that's what we'll chat about. So these are all the components of the actual application, the affidavit from the client, general evidence, country conditions, and then we'll talk a little bit about working with clients and answering questions. And then there's the actual I-589, the application. And then there's the interview itself, which is a separate process, preparing the client for that. And then there's a legal memorandum or the legal argument, and we'll do a whole separate training on that. So anyway, that's to say there's a lot that you file. Okay. So one of our big goals at Arise is just to give you simple enough explanations so that you can actually help. Because even though this area of law is super complicated, if you have a general working understanding, you really can contribute, especially if you're someone who's attentive to detail and good with people, understanding of things like past trauma and cultural differences, you really can contribute. So that's really what we're trying to do. Um, so for example, if you understood last week's presentation on the basics of asylum law, you can help a client write their affidavit. Sorry, I'm still admitting people. Um, and provide a huge service to the client and the person who's in charge of the case. One disclaimer, we're seeing a lot of unauthorized practice of law right now for all the obvious reasons. There's a ton of exploitation of immigrants. It's horrifying. It's also horrifying that legal remedies are sometimes impossible in those kind of scenarios. So at Arise, we of course are trying to train and equip non-lawyers, DOJ reps, and lawyers, but we of course want to do this in a way that is ethical. And so at Arise, we closely supervise all of our cases. So we don't get anywhere near that line of unauthorized practice. And we would never condone that in any way, obviously. But that said, you can still help out a lot if you're appropriately supervised. So I think that's an important nuance to understand. Okay, so our process, like, what does it look like start to finish when we work our cases at Arise? Because as I've mentioned, we focus on affirmative asylum. And you know that's distinct from defensive asylum, which is a case that's handled by an immigration judge. So we start with an intake. We have our intake form online. Prospective clients fill that out. I screen them all manually. A lot of times I have a little bit of back and forth with clients before we schedule them for our Zoom interview, where we vet even further to make sure that there's a claim. And then if we are going to take the case, we explain the whole process to the client as best as we can. Of course, there's so much to explain that we try to narrow it down so it's not completely overwhelming. And then we do a retainer where we set expectations. Once again, we would put any sort of disclaimers in that retainer if we have concerns about potential bars to asylum, for example. We would want to get that in writing just to make it clear that we advise the clients about the risks that they'd be facing if they were to apply, or since we would be applying for them because we're doing the retainer. We get a wet signature for the retainer or a signature through DocuSign. And then we get to work and we work up the case. As you know, asylum law is very much impacted by different types of deadlines. So there's the 1 year deadline for applying for asylum, which means you need to apply within 1 year of your last entry. But then we've talked about there's exceptions to that. And that looks different from client to client. So depending on that deadline, that's sort of what sets the pace for the case. And that's important because, if you have a 1 month turnaround for a case, which is actually something we're working on right now. We just took on a case last night. It's due in about a month. Then you have no choice but to work fast and to be aggressive. But if you do have time, that's really nice for all the obvious reasons for us. It's less stress, but it's also a more trauma responsive approach if you don't exasperate your client. So that's why pacing can really help, like being intentional about the pace that you go at. Because sometimes you just need to get in fast, but sometimes your case will be stronger if you take your time and you don't rush it. And your client might have preferences related to that too, because of course, the sooner you file your asylum application, the sooner you can file the application for the work permit, which might be an important objective for your client. So anyway, just thinking about the pace and how to structure things from the jump, that's really helpful. After you get everything you need, you submit the application. We generally do those online. There's a lot of benefits to the online system, even though it's super flawed. We've done a training on that recently. It's really just temperamental, and it will just wipe out all your data one day, and the next day your data will be back. It's bizarre. But there's a lot of benefits to the online system, so that's why we do that. It's easier for clients to monitor it online as well, as opposed to when you file through the mail. It can take literally months to get a receipt notice from the government. And then you don't really know where it is or what's happening. It's harder to get confirmation about what's going on in the case. If you have to supplement the case in any way, it's also harder to do that through the mail for all the obvious reasons. Whereas online, you can just click a button and see that your supplementary evidence uploaded. And then we prepare clients for interviews. This is also just another bizarre quirk. Our clients, what we tell them is that you're likely to fall into two options. One, you could interview very quickly, like right after you submit your application within a couple weeks. Or two, it could be many years until you interview. Those are the trends that we're seeing now. Of course, there's exceptions and weird things happen, but those are the two primary tracks as far as we know. In the past, even during the first Trump administration, up until very recently, the government would tell us these kind of things, like what actual trends were happening, how they were prioritizing cases, statistics related to like countries of origin, approval rates, that kind of thing. That is no longer the case. The government is just completely lacking transparency at this point. So that's why we can't even really tell clients like, it's you have a 40% likelihood of interviewing soon versus being placed in the backlog, in which case you'd may wait many years. So there's just a lot of unknowns right now, unfortunately. And then, of course, clients are called for their interview. We're in Pittsburgh. Our clients go down to Virginia to interview. It's about a 4-hour drive. They have to be there in person, have to bring their own interpreter. And of course, all dependents or derivatives need to come with them. So that's a high-level view of the process that affirmative asylum seekers go through. After they interview, it's completely unpredictable when they'll receive their decision. I'd say on average, in the 10 years I've been doing this, on average, for my cases, it's been 6 months to a year, but it can be as little as 2 weeks. Actually, we got a case last year approved in 3 days, fastest I've ever heard of, or it can be many years. Like I remember a couple years ago at an asylum office stakeholder meeting, the government mentioned cases that had been pending for 20 years. And this was a couple years ago before the surge in the backlog. So there's just so many unknowns. Okay, in terms of the intake, like how do we choose clients? Because I hate to use this terminology, but we kind of have the luxury of choosing clients because there's such a demand for our services. And so just for us being a nonprofit and wanting to steward donations and resources that we have well, we try to pick really strong cases just because these cases are a lot of work and we want to try to funnel our efforts into cases that will actually lead folks to freedom and autonomy and doing what they want to do. So this is what we screen for. General eligibility, sort of like what we talked about last week. Do you meet the qualifications? Do you satisfy the elements for asylum? Bars. So the bars for asylum can be expansive. Sometimes we have really good arguments that they don't apply, even though the government might think that they do. So just because a client could be subject to a bar doesn't mean we wouldn't take the case. We just have to have a good explanation as to why they're not subject to it. And this is an important point. So, for example, thinking about bars, I think the most common bar, if I were to guess, like across the country, is the 1 year bar. We know the government likes to deny cases on that basis. If you're going to file a case that's past that 1 year date, you have to have an argument as to why the person meets an exception. Otherwise, it's unethical. As you all know, my husband prosecutes lawyers for ethical misconduct, and this is something he sees a lot, actually. And it's to me, it's kind of obvious, but I guess it's not obvious enough across the field. But it really puts clients at risk if you file and there's a bar implicated in their case, and we don't have an explanation as to why it doesn't apply. And it's just something we shouldn't do because it's unethical. Okay, and then workability. This is kind of the factor that we're screening for that might not be as obvious. So, do you have an interpreter? Not just that speaks the language, but that can work in this kind of environment. Or maybe even that can build rapport with the client. Or is the client comfortable with the interpreter? We've had instances where clients have been really uncomfortable with the interpreter, like there was actually an exchange of insults between the client and the interpreter. So those factors are important. Is the client willing to put in the work? That's a big one. So I'd say in general, our clients are pretty motivated and they have an understanding that this is an intense process, and we try to communicate that. But I'll give you the warning signs. If you have a client that no-showed twice and seems to have a strong case, but they're really late on the third time you try to schedule with them, I would really think hard about taking on that kind of case because you can get into a situation where you're coming up on a deadline, you've already been retained, and then you actually don't have enough to file. And there are ethical issues in that scenario. So, on top of the professional responsibilities that we carry as legal advocates, it's also important to consider, well, even if I do file a case that's maybe not as good as I want it to be because the client's not invested, well, are you putting them at risk if you do that? Would it be better for them not to file at all? I think those are really good questions to ask, especially in this environment. So you're screening for workability. Is the client up for it? Do you have the resources? Do you have the arguments? I'll pause there for thoughts, questions. Okay.
Yeah.
And then, Oh, sorry, go ahead.
Um, some of that's hard to know when you're just doing the screening. What if you get into a situation and then realize it's not going to work? Or you discover something like a bar?
Yeah, it's a great question. Okay, so we'll use specifically the bar example. Couple thoughts on that. If it's a situation where you have an argument, you explain it to the client, you explain the risks, they want to go for it anyway, they have no other option, that's one thing. If that were the scenario, I would put it in writing. So I do these notices where I map out what the issue is, what the risks are, and that they understand the consequences, the risks, and they're okay with it. They want to go forward. I put all of that in writing. That's really important for us. We have to protect ourselves in this environment. And of course, we want them to understand so they can make their own decisions about their life. So that's one thing. Sort of on the other end of the spectrum, say it's a bar, and I really think there is absolutely no argument. There have been situations where I have um, told the client, like, now that I'm aware of this information, I think you're absolutely going to be denied. I actually think that you're putting yourself at more risk by applying. So I can't move forward with this information. That, though, is rare because ideally you're in a situation where the person doing the intake and taking on the case is experienced enough that they can screen for this. So you're not in that situation. When I have been in that situation, it's usually because the client doesn't tell me something, like they withhold it and then it comes out. And I think that's perfectly acceptable to withdraw at that point, like when they've withheld information. It gets really tricky because withdrawal um, is tough because you're generally not supposed to prejudice your client, you know. There's, of course, ways to do it by giving the client notice and helping them find other counsel if that's a possibility. But yeah, it gets really tricky. Yeah. Any other comments, questions? One nice thing about doing pro bono work is that we don't charge clients anything, so we don't have to give money back. I remember when I used to work at a firm, I was assigned a couple of cases that my boss thought were arguable. These were asylum cases, and I got them and I said, no, we do not have good arguments here. You know, to me, it felt like stealing money, um, and just setting clients up for a long road of just continuing to pay legal fees. And so in that situation, we had to refund money, which in a law firm setting, no one wants to do that. So that's one nice aspect of nonprofit work, especially if you're not charging money, is that, you may have done some work, but the client wasn't spending their money to fund it, and you don't have to deal with refunds. Okay, the actual components of the filing. The affidavit. So you can have different affidavits from different people for an asylum filing. The main one is the one from your client, the person actually applying for asylum. I think you should always include this. Um, just another argument in favor of not including affidavits. I've heard attorneys say before that they're worried their client will contradict themselves in an interview. I think it's a huge credibility concern and just looks really sloppy, frankly, if you don't file an affidavit. If there are issues with memory because of trauma or even like a cognitive issue, those things are really common in this line of work. Document it, put it in the affidavit. Say, like, I have issues with my memory, and try to get a mental health evaluation to accompany that. But I would always file an affidavit. And then you can, of course, get corroborating affidavits from other people, witnesses. Remember, the rules of evidence don't apply in an affirmative asylum context, so hearsay is perfectly fine. Maybe you're really light on evidence for a case, so your client has a best friend that they've told everything to, so you just get an affidavit from that best friend regurgitating what you already know because it's just some corroboration for what your client said and helps boost their credibility. Number two, evidence. So evidence is very, very broad for an asylum case. What you want to think about is, how am I proving the elements for asylum. What can I use to actually show that past persecution happened? I know that folks who come through our trainings have really diverse backgrounds. So some of us went to law school, some did not. Some of us have worked a lot of cases, some have not. But the term that they use in law school is probative. So probative means tending to prove a legal requirement. So that's obvious in this kind of casework, right? You're trying to prove one of the legal requirements for asylum. But when you're dealing with really messy facts and a ton of requirements, it's actually easy to lose sight of that. So that's why, if you remember in my last presentation, when I mapped out the core requirements for asylum, you want to make sure that all your evidence would fit into at least one of those requirements. So, for example, pictures. Pictures are really helpful. Was your client tortured in prison? Is that the basis of your claim, the past persecution? Take photos of the injuries. You just want it to be highly relevant and also very clear, like what you're trying to prove, which element. Country conditions, you're documenting the situation in the country, the reason why they suffer persecution or they fear it in the future. The brief/legal argument is the reason why your client satisfies the legal definition for a refugee. And we'll do a whole nother training on that. The application for asylum is comprehensive. The government wants to know a lot of information about folks who are applying for asylum. So if you haven't looked at that, it's useful to really familiarize yourself with that before you take on a case. And then there's the interview prep. So we'll go over all of these briefly. So this is a super busy slide, but I designed this to be kind of a checklist for you. Like say you're going into an interview with an asylum seeker for the very first time. Take a screenshot of this so that right before you do your interview, you kind of have a guideline and tips to fall back on. So I won't go over all of these, but I'll highlight a few. So kind of like what I was saying about the probative value of evidence or the probative value that you're pulling out to put into an affidavit for your client. Think about those core elements and go from there. It's very easy to stray off into kind of random things. Like a lot of times clients like to talk about just the general circumstances in their country because it's what they know, it's what they're thinking about. It was their whole life before they fled to the United States. A lot of that's irrelevant. So it's one thing to sort of build rapport with your client, be respectful, be patient, and sort of wade through those waters with them and listen. But it's another, to pull out what you need to put it in the affidavit. So at Arise, when we're helping clients write affidavits, usually what we do is they talk and we type out what they're saying. I would say for the first meeting with clients as we help them write their affidavit, I'm listening and only typing out maybe 30% of what they're saying because the rest of it's irrelevant. But I don't want to, like cut them off repeatedly. That hurts rapport building and isn't always helpful. So keep it relevant even though, your client might stray. And then in terms of this, this idea of helping your client write the affidavit, there's a lot of ways to do it. I know we've talked about this before. You can give your client the option where they write it out themselves and then you come back and help them edit it, making sure they include everything they need to. Or you can do it the way we usually do and ask the right questions so that you can get it right from the jump and just type out what your client says. One helpful thing I've learned from mental health professionals is this idea of an arc. So, in any asylum case, you're going to get traumatic material. You're going to have to discuss that with your client. So, the idea of the arc is really simple and straightforward in that you start with a lighter material, you work your way up into the traumatic material during the interview. So, high trauma stuff would be in the middle of the interview, and then you work your way back down. So like for example, last night we did an intake. It got pretty heavy. Some pretty dark stuff was shared in the middle. I realized we had enough to take the case, and thankfully we were able to bring it back down and end on lighter topics. But part of this is just, our clients are dealing with unbelievable stress because of the enforcement that's going on right now. the very fast deportations, the third country removals, I mean, you name it. So our hope is that we just minimize some of the damage by being intentional with some of those trauma responsive practices, like keeping the arc in mind. Sometimes it's not possible. You know, sometimes you'll have a client break down and they want to stop. And so, of course, that's the right thing to do is to tell them, like, let's take a break and revisit this. So it's never a perfect science, but we try to do what we can to avoid inflicting more damage. Keeping it short and relevant. So I'm talking specifically like about the length of the affidavit. So when I first started doing this work, my affidavits were super detailed. For my first asylum trial, so it was a defensive asylum case, my affidavit was like over 20 pages for the client. I would never do that now. One, attention spans have shrunk. That's a documented phenomenon. And then two, the backlogs have surged. So there is less time spent on the adjudication of each case. So we really just try to condense everything so that it's easy to digest quickly. And that's especially true of the affidavit. You want it to be a quick, easy read so the adjudicator understands right away. Okay, let's see. What else do we have here? So, common issues that you see. Um, the the human capacity to minimize harm is really impressive in many ways. Our clients are really brave. So again, pulling from last night, we did an intake for a woman from Ukraine. It was very interesting to hear her talk about her experience as she was living outside of Mariupol. Russian soldiers came and took her from her home. And she was describing what happened. She said, you know, basically I was very nice to the soldiers, like I was trying to like keep the peace. Her neighbors were like escorted out. They were sorting people. They were, you know, making them undress, all of this very alarming stuff. It was interesting to see the way that she explained the experience because if I were to explain what happened to her, she was forcibly abducted by gunpoint by Russian soldiers who would kill her if she didn't comply. That's the way I would explain it. That is not at all the way she explained it because she was minimizing the harm. A lot of people went through this. This is just how she internalized this event. So the interesting thing about asylum cases is that we're kind of like caught between our clients' bravery and their coping mechanisms, which are usually impressive, and what we need to do as advocates to explain the actual risks. So, like we've talked about before, like we never want to exaggerate or say anything that's untrue or help our clients say anything that's untrue. At the same time, I think it's really helpful to be aware of these like psychological things that happen so we can help our clients tell a story in a compelling way that's legally relevant. So, like we were talking about last night, if it were me working up that case, I would ask her, like, do you understand that you were abducted? Like, is that your understanding of what happened? Like, you were kidnapped or abducted, as opposed to the way she kind of said it the first time, which was, oh, they came to my house and asked me to leave and said I should come. And there's a difference there. But I think, especially now in this environment where people are not given much process, the onus really is on us to help our clients understand the differences in the versions of the same story so that they can put themselves in the best position possible to win their case. Another issue we see a lot is like unpredictability in terms of clients' behavior or their storytelling abilities, their memory lapses because of not only past trauma, but also like this very repetitive nature of our interviewing. We have to go back and ask the same stuff to make sure we're getting the sequence right or getting some of the details right. And so all of that can just be disorienting for clients. So it's not uncommon to see inconsistencies or even to see clients behave in a way that might make us sort of suspicious. That's something that I see a lot in folks who are newer to this work. And I remember this about myself too. I think that the more you do this work, the less suspicious you become. of client stories because you actually realize that the world is extremely dangerous. Um, at least that's been my experience. I think it's the same for many other folks doing asylum work. But it's something to be aware of because it's easy to make assumptions. And clients might behave in ways that seem like odd to us or in ways we don't understand because of the cultural differences, the language barrier, the education barrier, the fact that not only they were traumatized, but now they're reliving it in this environment where they're afraid of being deported back to what they fled. So it's just helpful to be aware of that and to sort of understand that it's part of the process. Last tip I have for you is that the last one on the slide, short and simple questions. Super helpful. Hard to do in practice sometimes because of the level of specificity that you need because the legal requirements are so complicated. But I think especially when you're first starting your interview with your client, really try to keep it short and simple because it's less overwhelming for your client and gives them more autonomy to tell their story in the way that they want to, rather than you just diving in with those super direct questions. Okay, I'll pause there. Comments, questions? Go for it, Jennifer.
Okay, two questions. One, is it okay to put things in a different order than your client told you? If you want to put it in chronological order, if you want to consider primacy and recency effect, that they're not going to be thinking of that. That's one question. And
Absolutely.
then, is it okay to explain to clients a general knowledge that you have that sometimes people use coping mechanisms to minimize harm because they're not going to necessarily be aware that that's what they're doing. But if you talk in general, you're not coaching them, but you're explaining that this may be something that happens.
Yeah, both great questions. So, first question, yes, like I think that's effective advocacy to try to put the story in sequence because that's what Western readers are trained to do. And your adjudicator is most likely, born and raised here. And then also primacy and recency, like it's really smart to be aware of those things, that's a bias that exists in our brains. Just one thing to keep in mind with that is just make sure you have your client verify the affidavit. So read it back to them if they're unable to read or write, or have them read it and make sure that it's correct. And then your bases are covered. Yes. Um, and then, yeah, your second question about sort of talking about the mental health effects of what they've been through. Yeah, I think where this comes up the most is during interview prep. So preparing them for their asylum office interview or testimony if you're in court. It's really the same dynamic. So yeah, like the way I've handled this pretty frequently is I've told clients, you tell your story in kind of a detached way. It seems that you're really strong. This is the way you've dealt with it. But I would encourage you, like, if you're afraid, and I know you are, you've told me that, give voice to that. Like, it's perfectly acceptable for you to break down as you're testifying, to cry, to ask for a minute. I really try to encourage them that um, they can sort of lose it, like they don't have to keep it together. Because a lot of clients kind of have that expectation that they do have to keep it together. And so actually, it's been a joke. I've told clients before when they feel like they have to be so buttoned up. I've told them before, like, look, if you cry, that helps your case. It's a joke, right? It's tongue in cheek. But my point is, like, if you show the sincerity of your fear, that helps your credibility. So don't fake it. That's not what I'm saying. But I want them to feel comfortable enough to tell the truth. So this kind of stuff is a little hard to articulate, right? Because there are some people who take this too far, of course, and that can actually lead to exploitation. But the whole goal is we're trying to help them tell the truth and and advocate for themselves in the best way. Okay. Country conditions. So this is one of the best ways to jump into an asylum case if you're new to this work. So we have an 18-minute explainer video. If you log into like these slides on my Google Drive, you can access this YouTube video. It's really good. And then this is a redacted sample table of contents. The way we do it is we do an annotated table of contents. So we pull out helpful quotes from our sources that corroborate not only the client's like factual claim, but also the elements that we're trying to prove. So here's just some tips for you, some practical tips. One thing I will say about country conditions research is going back to that idea of probative value of your evidence and your sources. One of the mistakes I see people make when they're new to this work is they try to use country conditions as an opportunity to just corroborate what happened in the client's case. So I'm going to use myself as an example, okay? Say that I am an independent. I'm a registered independent in America, okay? And I go out and I protest this administration. And this happened yesterday. I think it was July 15th, right? Yeah, July 15th, I went out and protested, okay? And the Trump administration came after me and everyone else who was protesting as registered independents protesting this administration's policies, okay? You could, if that was like the basis of my asylum case, talk about like find sources that said, yes, there was this protest in Pittsburgh on July 15th, and this happened, and this happened, and this happened, corroborating what happened, right? Or what would be better is if you focus on the legal requirements, especially nexus, and you find documentation that, oh, the Trump administration, he hates independence. The whole administration, they hate independence. They are targeting independence because that's the nexus, right? The nexus on account of the political opinion. And that would be more helpful than just corroborating simply what happened. So you can do both, but the point is like try to keep your research focused on the actual legal requirements and not just corroborating the facts of the case. Because I think nexus is one of the hardest elements to prove, and adjudicators like to deny cases for failure to satisfy nexus. So just the one more thought about corroboration. The biggest reason why that's helpful is because it tends to show that your client is credible, they're not lying. And in this environment, we know that there's really unreasonable expectations about client credibility. So that's helpful. Like if you can have evidence explaining like, yes, this actually happened, like she said it happened, that's good. It's just try to pair that with the legal requirements. That's best. Okay, evidence collection. So we've mentioned evidence is super broad for an asylum case. Remember what it can and can't be. So regardless of how you're filing, like through the mail or online, it has to be documentation, like paper. It can't be a video or a recording. That said, if you have really good evidence that exists in one of those two forms or something else that's not documentation, your client could mention it in the interview and bring it to the interview. So say they got a threatening message over Facebook, like a video from their persecutor. You could approach that, like file it by taking screenshots of the video and notating like what it is, what's being said, et cetera, transcribe it and upload it that way. That way it's actual documentation. And then mention in your filing that you'll bring the video to the interview and then ask the officer if you can play the video for them so they can see it. So there's lots of ways to get creative with these cases, even though there's some restrictions. Um, Things not to include, anything that's contradictory. One of the big issues that I've seen is identification that's contradictory. So it's really common in conflict zones for countries to be really bad at producing identification. So if you followed things with the Trump administration, they're using that as a basis to deny all kinds of immigration applications. But like it's an impossibility. If countries are at war, they're not functioning, of course, they cannot produce proper identification. So, say you have a client with an issue on their birth certificate, like their name is misspelled, their birthday's wrong. Well, consider not including that, especially if they have other ID that's accurate. Also, never include anything that could be harmful. There's so many different ways that documentation could be harmful. But I'd say the biggest way is just that it doesn't help. Make sure that everything you file actually really does help. I think that this is pretty obvious, especially for folks who help us on our cases. But one thing I have seen, and adjudicators talk about this a lot, is that um, advocates will just flood the government with volumes of evidence and country conditions research that really is not helpful. And volume doesn't make a case. What makes a case is clarity and understandability, even if your evidence is sparse, because sometimes there's just not a lot of evidence. I mean, we're dealing with stuff that happened in another country, so that in and of itself makes evidence collection hard. Expert witnesses. So there are a couple different kinds. Country conditions experts. So they are engaged to explain the unique risks to your client. So specifically, they would zone in on nexus and protected ground. You can find them at the Center for Gender and Refugee Studies. We've also found a lot just through Google searches or just personal connections, reaching out to the AILA listservs, you name it. There are lots of generous academics and folks who want to help out with these cases, but usually you have to pay for them. And then there's psychological and medical evaluations. So psychological evaluations document issues related to PTSD, cognitive issues. There's lots I could say about this. I know we talked about this last time, the extraordinary circumstances exception to the 1 year bar. It's really helpful to have a mental health evaluation of folks who were prevented from filing because they were avoiding talking about their case because of PTSD. And that can be a way to overcome the 1 year bar. And then in terms of medical evaluations, they can be used for a lot of reasons too. So female genital mutilation, that's been a really common one. Um, Evaluations of scarring and injuries to basically say, like, yes, this is the pattern of the scarring, this is the nature of the injury. It's consistent with this person's explanation of how the injury was sustained. Again, that's just really showing credibility that your client's telling the truth, even if it's really obvious. Like, I've had cases where it's really sad, like clients have been burned with specific objects. And so I've taken them to doctors and had the doctors say, like, what all of us lay people know, like, yes, that's what happens. This is how an injury happens when you're burned with like a star-shaped metal thing. But still do it. Like in this environment, the government will make up all kinds of reasons to say your client is not credible. So it helps to have someone with impressive credentials explain their understanding of what happened or what could happen in the future. What could happen in the future if the client's forced to return. I'll pause there. Comments, questions?
For the medical evaluation, does it need to be a specifically trained physician, or can it be like their own regular doctor if they have one?
Generally, it would be someone trained to do forensic evaluations of asylum seekers or people seeking humanitarian relief. There's a lot of reasons why the training's helpful. That said, if it's something like, say your client is suffering from a medical disorder because they were imprisoned in their country and like they were exposed to a lot of smoke when they were imprisoned, right? And now they're suffering from some sort of medical condition as a result of that. If there's something like that where you don't need that expertise related to the legal requirements or like the actual process the client has to go through, that could be very helpful. Because you're not having the medical doctor say, like, yes, they were in prison and there was fire there. No, they would be like handing over the documents, and you might ask for a letter saying something like, this kind of respiratory illness is caused by exposure to smoke. So, yeah, I could definitely see a scenario where you get documentation from someone who has absolutely no idea about like the immigration legal process. But if it's more like in depth, explaining credibility and like understanding if it requires understanding of how the client's going to testify, that's quite different. So I don't think I ever have requested documentation from a physician um, outside of like a human rights clinic. Okay. And then the legal brief. So we'll do a separate training on this, um, like how we write those, what you want to include, how you can be persuasive, but also try to keep things simple enough so that the officer wants to approve your case, that kind of stuff. We'll do a separate training. Okay, the 589, we're also doing a training on that. One of the reasons why we're doing a whole separate training on just the application is because of the issue of pretermission. The government is dismissing cases without evidentiary hearings for a lot of reasons. One of those reasons is inadequate information on the I-589. So we'll be talking about how you can do that thoroughly and in a way that kind of mirrors your legal argument that you're making in your brief. So I'll reserve chat on that because we'll do that at our next training. Okay, so for the interview prep, like I said, it's super unpredictable when clients interview. Wish we knew more about what to expect so we could inform our clients about how to actually plan for their lives, but we just have no idea. The interview prep. There's three components of that. And usually we deal with this like right after we submit the I-589 because the process of assembling the case is so intense that you usually don't want to put the cart before the horse and deal too much with the interview until after you've submitted the case. Because one, it's overwhelming for your client, and two, it's overwhelming for us. So try to submit the application, then you deal with the interview stuff. So the way we do it at Arise is we create a prep sheet that's about half a page. So what we do is we take the client's affidavit and we pull out bullet points of the most legally relevant facts of their case. And it should be no longer than half a page. We give it to the client if they're able to read. I'll explain how you do it if they're not able to read in a minute. And you tell them, look, this is the most important part of your case, these points. Regardless of what questions you're asked, I would encourage you to explain these points in your interview. If the client cannot read, you can do a recording with them so they can listen to it. Or you can practice with them and just remind them verbally, like these are the 3, 4 points that I want you to talk about. Um, and so the first question, the first substantive question folks are asked in their interview is usually, why are you applying for asylum? So a good answer to that can often win the case. And that's one of the reasons why that prep sheet is so helpful. Because if they can remember about 80% of what you put on that sheet, then they're going to give a great explanation to that first question, which is an open-ended question, and that will put them on a path to interviewing well and hopefully being granted. And then being trauma responsive, a huge part of that is helping clients understand what to expect. If you do a case with us, Vero is awesome at this. She's going to take the lead on the case that I mentioned we interviewed for last night. She's really good. Like each time she meets with a client in general, she gives them a preview of what to expect. That is so nice. Like that is something the mental health professionals always tell us. Like try to like give notice about what you're going to talk about what is actually going to happen because it just like lowers the stress response for clients. So of course we do that as much as we can for an interview, explaining what the room looks like, explaining what the order of the questions tends to be within reason, right? Explaining how long it usually is, that kind of stuff. And then in terms of getting them ready to actually answer all the questions, we do a moot session at least once. We usually do three with each client before they interview. And that's where one of us pretends to be the asylum officer and they pretend that they're in the interview and answer the questions. And then we give them feedback. Okay, that's all I have. Questions?
Is pretermission just in defensive or is that in affirmative cases too?
So it's only, well, it's a great question. All your questions are really great. Um, so it's only happening in like a clear way in removal proceedings. But this is why I hesitate. And actually, I'm putting together an Immigration 101. I'm going to do it probably like the first half of August, and I'm going to talk about this. This is why I hesitate. So we're seeing something very new happening. It used to be that if you applied for asylum, you had the right to remain in this country until you had an actual adjudication of your claim. We're like on the other end of the spectrum now. Now what we're seeing happening is folks are applying for affirmative asylum. They have violated zero laws, and they are being transferred from the asylum office to the immigration court, and then their case is pre-terminated. So
Hmm.
that's almost pre-terminated in both agencies. Like that's the way I would see that. But formally, it's happening by an immigration judge who then usually orders them removed. Yeah. Go ahead, Pat.
Um, so you described the big need for this kind of work with individuals, and I was wondering, how do people find you? Are they all referrals from um, some other agency? And then how do you decide? You described how you look for strong cases, and I understand that and all the reasons why you would need to do that. But I'm wondering, do your clients end up being a range of countries, from a certain, is it more likely for them to have more the basis for their claim being of a certain kind, et cetera? I'm just wondering, both the volume perhaps of people you have to turn away, and
Mhm.
just get a little more feel for who you're left with and if there are ongoing patterns in that, or does that fluctuate over time?
Yeah. So, your first question, generally our referrals come from other agencies. So we're the only organization that focuses on asylum in Western Pennsylvania. And there's a huge need. And then second, our clients are actually super diverse. It's not really by design. I really screen for strength
Mhm.
of the case. I think that's the best way to meet all of our objectives and to serve people well. But yeah, super diverse in terms of country of origin. Yeah, in terms of the demand, what's really sad right now is that our intakes are actually down for specifically affirmative asylum because so many people are in removal proceedings. We are
Mm.
getting a ton of requests for help for defensive asylum, which we generally have to turn away because those cases have become extraordinarily complex. So they're just resource draining, and we don't have the resources. We're a really small nonprofit. So, yeah, our intakes for like what we actually do are down. But that said, like there's a ton of people, and I know this in Pittsburgh, who have lost temporary status, whose only option is to apply for asylum. A lot of people are not presenting themselves for help, because they're so afraid or other issues. They're just trying to survive, pay their bills. They lost work authorization, you name it. Or they might even think that it's impossible because they watch the news. So there is a demand that's not making its way to us for what we do specifically, but this is more of a recent trend. Kind of circling back to what you were saying about like you know, diversity of claims. When we first started, we focused on Afghan asylum
Mhm.
because it was a really unique situation. Afghans were statutorily prioritized for
Mhm.
adjudication, which never happens.
Mhm.
So we thought, oh, this is a great way to help people really fast. That never happens. So we were able to help maybe like 40 some people get asylum really fast, which was
Mhm.
awesome.
Mhm. Mhm. Okay. At any given time, is what kind of caseload do you have? And I understand there are fluctuations if you described it, but I'm just wondering, are you crazy busy with, I don't know, a dozen cases at the same time, or do you actually, how do you, what's your caseload, I suppose?
Yeah, so active cases right now, it's probably 80 something,
Wow.
but these aren't just asylum.
Hmm.
So, yeah, just for you to have a better understanding. So, there's four of us on our core legal team. Kim's here. I think Kim's the only one here, right? So, Kim's a DOJ rep. We have Vera, who's a DOJ rep, and Valerie, who's a DOJ rep, and then myself. So, we work really closely together, and
Hmm.
we all handle cases like individually in the sense that one of us takes the lead usually, and then we all support each other. So, I think it's 80-ish that are actively pending. And then, so we've only been taking cases since early 2023, and I think about 60 of those have been adjudicated. And all of our adjudicated cases have been approved.
Okay.
Yeah,
Thank you.
sure. It's helpful to know that. We haven't had denials. Like, we all need encouragement right now. It's really depressing. So, yeah, it's helpful to know.
It's a dismal environment. It,
It's horrific. Yeah, it really is. Any other questions? Okay. Well, thanks everyone. I'll send you out a reminder for the next session that we have. I think the next one is on the I-589, so I'll send an email. Well,
Thank
have a
you.
great night and thank you all for hanging out. We'll see you all.
Thank you.
Thank you.